Next up, we're going down to Cape Town again. Severely difficult, complex, and a lose-lose situation. Relocation of RH versus NM, which served before Uber AJ, a 50-page judgment. You can find the summary on page 19 and the bundle, page 303. Safely citation, ZAWCHC 77. This is one of those matters where one certainly has deep sympathy for the judge, because this could not have been an easy matter to adjudicate upon. The parties were unmarried parents of an 8-year-old boy, L. The applicant applies for leave to relocate with L to Australia. The respondent counter-applies for leave to relocate to France. In this matter, several expert reports had already been filed. At that stage, I speak under correction, but I think it was 4 or 5 expert reports, including various dissenting opinions and views and recommendations. The court looks at the Children's Act, sections 18 and 7. The court looks at section 28.2 in terms of the best interest. The court looks at the Plaskon-Evans rule, and as you can see, very interesting on the page from a technical point of view, the court says Plaskon-Evans rule is virtually impossible to apply, given that the same issues and disputes have relevance to both the application and counter-application. It's not feasible to assign factual disputes to either the application or the counter-application. So why is this judgment important? It looks at the detailed exposition of decision-making where there is no obvious right or wrong. There is going to be a clear winner, clear loser. It is a very profound Solomon baby scenario in terms of what the court had to do in this case. The court was essentially guided by some of the experts. The order consists of 30 different orders with sub-paragraphs, a very thorough order by Uber AJ in terms of the relocation. And essentially, the respondent was granted leave to relocate to France. However, there was provision made for the child to reside with the applicant in Australia for a year once he is 13 under certain conditions. And the 1 year, I believe, had something to do with getting a visa for Australia for the child, and that was one of the points that was raised. Very interesting quotes from this judgment. There is such fierce contestation and acrimony between the parties that their experience and narration of events is more than likely somewhat clouded by bias and self-interest. This is not unusual in matters of this kind. And then the court reverts to ID versus SP, refers to the Plaskon-Evans rule. And then, very interesting, the court says, well, the parties say a lot of things, but I essentially went back to looking at the experts. Moreover, the various expert reports that have been filed provide more valuable information needed for its resolution than the evidence of the parties. And that was RH versus NM, making your head spin all the way from Cape Town under the pen of Uber AJ ZAWCHC 77, page 19 of the summaries, 303 of the bundle, and it is a 50-page judgment.